Okay, good afternoon, everybody. Sorry if you hear fire engines going by. They're going by where I am in Brentwood. My name is Steve Rauscher. I practice at Rubin, Rauscher & Blum, and I'm joined today by Michael Sohigian of the Law Office of Michael Sohigian. This is I've sort of lost track as to how many years Mike and I have been doing an annual update. We did them religiously year after year until last year, right around this time, a little thing called the pandemic hit. And so we missed 2019 and 2020, but this year we're going to do 2020 and in 2021. We are going to do our best to answer your questions as we go through the presentation today. If you have questions, please feel free to use the question and answer feature or the chat feature. And the person who's not talking will try to monitor that and see if we can't pose the questions as we go along here. We have a lot of material to cover today, and we probably won't get to all of it. But all of the cases that we thought were significant from 2020 are in the materials that were sent to you. With respect to the materials, if you missed them, they are available. There was a link to them in the 1 hour reminder email that was sent out, and they're also in the chat so that you can download them. You should all be receiving your certificates of attendance within about 24 hours of today's program, so be on the lookout in your email for that. There will also be a link to reviews if you want to evaluate the program. So I'm going to get started. Mike, did I miss anything?
No, I think that's all. Good
Okay.
job, Steve.
Okay, great. Thank you. We have our program segmented into various areas of interest with respect to insurance: first-party policies, third-party policies, insurer versus insurer disputes, and bad faith. And we want to make sure to get to some of the bad faith, which is towards the end of the program. So I'm going to start with first-party policies. Normally, we start our program based on what the biggest California Supreme Court case on insurance was. But this year, the California Supreme Court case on insurance had to do with insurer versus insurer disputes, and we didn't want to put everybody to sleep right at the beginning of the program. So instead, we decided to start, as I share my screen, we decided to start with a couple first-party policy cases. And the first one that I'm going to talk about involved a marijuana growing operation. The facts of the case in Mosley were that Mr. Mosley was a landlord. He rented out his house, which was insured by a homeowner's policy issued by Pacific Specialty. Apparently, unbeknownst to Mr. Mosley, the tenant was using the house as a marijuana growing operation. That probably looked something like this that we pulled off of the internet. Of course, there was a fire in the house, which was caused by the tenant's rerouting of the electrical system, and Mr. Mosley submitted the fire claim to his homeowner's insurer. The problem for him was that the policy excluded any loss associated with the growing of plants or the manufacture, production, operation, or processing of plant materials. Clearly, the insurance company had this risk in mind when it drafted this.
It's an unusual exclusion in my experience.
Yeah, exactly, but probably less and less unusual nowadays. So Pacific Specialty denied the claim, and which led to the lawsuit. The trial court granted summary judgment for the insurance company. But on appeal, the insured argued that if the exclusion barred coverage, the policy failed to comply with the minimum fire coverage that's mandated by Insurance Code Section 2071. So this is somewhat unique to fire insurance in California. Notwithstanding what your insurance policy may say, there's certain basic minimum coverage that all fire insurance policies have to have, not homeowners policies in general, but with respect to fire coverage, certain minimum requirements. There's actually a form policy in Section 2071. And one of the things that Section 2071 says is that there's a limitation for coverage for hazards within the insured's control or knowledge. And so the issue was whether on summary judgment, the trial court properly found that this marijuana growing operation was within the policyholder's control or knowledge. And the Court of Appeal found that an insured increases a hazard within its control only if the insured is aware of the hazard or reasonably could have discovered it. And since there was no evidence in the record that the hazard was within the policyholder's control, the summary judgment ruling was reversed. There was also a bad faith claim in the underlying case, and the Court of Appeal affirmed the grant of summary judgment on that based on the genuine dispute doctrine, which we will be hearing about more from Mike a little later in the program. The second first party case that I wanted to talk about was this one, St. Mary and St. John Coptic Orthodox Church, which has an unusual set of facts. The Pope of the Coptic Church, which is a Christian church in Egypt, asked that this local church, Coptic church in Northern California, purchase a home to be used as his papal residence in the Western United States. And also that the idea would be the home would also be used for visiting bishops. So the church purchased the vacant home, and its insurance broker added the residence to its existing commercial policy, which was issued by Philadelphia Indemnity. So unfortunately, 57 days after policy inception, the insured reported a water damage claim. And Philadelphia Indemnity denied the claim because there's a vacancy exclusion in the policy, which says that where the loss occurs and the home has been vacant for more than 60 consecutive days prior to the loss, they won't pay for any water damage. Now, for reasons that are unclear from the case, Philadelphia nonetheless ended up paying the church $461,000 to do repairs. But as part of that, they agreed to characterize that payment as a loan, not as the payment of a claim. And in return for the loan, the insurance company received an assignment of a broker negligence claim against SBC to be repaid only in the event they were successful in suing the insurance broker. The trial court granted summary judgment to SBC, finding that it had been negligent, but that there had been no damage as a result of the negligence because the loss should have been covered under the policy. The Court of Appeal reversed, finding that there was no coverage under the vacancy provision, and therefore there was liability on the part of the insurance broker. With respect to the vacancy provision, the argument by the policyholder or by Philadelphia Indemnity was that the 60-day exclusion could only be measured back to the date the policy incepted. And what the Court of Appeal found that no, if the house was still vacant even before the policy went into effect, the vacancy exclusion applied. So that argument was shot down. But still, there was a question of, well, was it really vacant? And the policy said that a building or residence in this case is vacant when it does not contain enough business personal property to conduct customary operations. And so the question then became, well, what does that mean? What personal property needed to be in this papal residence? The papal residence was unfurnished except for a single chair and some appliances. Plus, I should add, there were window treatments, a plant, and toilet paper. But the Court of Appeal said, no, that's not enough to constitute sufficient personal property to conduct operations. And then with respect to pre-policy inception, the argument that was made was that, well, the building couldn't really be considered vacant because the house was on the market, and that was the business of the house, to be on the market, and the court did not buy that. Lastly, with respect to this case, this concept of a loan receipt agreement is an interesting one that I haven't come across really before. And you can imagine that they can be disfavored in certain circumstances, but in this case, the court said, no, it was a legitimate loan receipt agreement because, in fact, Philadelphia did not have any contractual liability to St. Mary, and therefore the agreement was not a legal sham for payment of an undisputed obligation under the policy. So this idea of a loan receipt agreement, I think, is something, to keep in mind in situations where you have carriers denying coverage, and where that, in particular, where that denial may result from some kind of malpractice on behalf of a broker. So that brings us to third-party policies, and I'm going to turn, unless there's any questions so far, I'm going to turn the mic back to Mike.
Thanks, Steve. Yeah, I would think that would only be in a case where you've got some third party that you could recover from, because otherwise you're just getting the loan. And if the validity of the loan, the not subterfuge, is based on the fact that there's not coverage, you can be sure that the carrier will come back to get the loan paid back, and maybe there might be interest payments and the like. All right, Philadelphia Indemnity versus SMG Holdings. SMG Holdings was the company that managed the Selland Arena, which is the Fresno Civic Center, where the Future Farmers of America had their convention. And SMG was required under the license, which is how Future Farmers used the property, to be an additional insured. And apparently the policy did not actually name SMG, but it had a deluxe endorsement that had the language that you can see on the screen, which in essence, SMG argued provided coverage. But that wasn't really the issue. The issue in the case had to do with arbitration, because SMG, of course, tendered a claim. Philadelphia determined that SMG was not covered, and they tried to invoke an arbitration provision in the policy to determine the coverage issue. So you can see the reason that they denied coverage was that the policy provided coverage for leased premises, which didn't include the parking lot, only the convention center itself. And the coverage for additional insureds was limited to things caused by the named insured's negligence, and the Future Farmers wasn't alleged to have been negligent in this regard. So after Philadelphia denied coverage for SMG, it tried to take the matter to arbitration, and SMG argued, well, wait a minute, you told us that we're not insured, so therefore the contract, the insurance contract that contains the arbitration clause, doesn't apply to us. But the Court of Appeal did not agree with that view, and they affirmed the trial court. The trial court the trial court denied Philadelphia's petition for arbitration, but the Court of Appeal reversed on the theory basically that SMG had sought benefits under the policy, namely coverage, and even as a non-signatory, it was stopped from avoiding arbitration, having knowingly sought the benefits of the policy, and the court found that SMG was a third-party beneficiary based on the language in the license that said FFA had to get coverage for SMG. And the claim alone, the court held, equitably stopped SMG from arguing that the arbitration provision didn't apply, even though SMG had not received any benefits. They had claimed benefits under the policy, and the court held were therefore stopped from denying the applicability of the arbitration provision. Okay, Textron is basically the underlying case in Textron is an asbestos case. And it involved, the underlying case was Esther's, a woman who sued for exposure to asbestos and mesothelioma. And Textron was suing Travelers for coverage. Travelers defended and settled Esther's case under a reservation of rights. Textron sued for declaratory relief. Travelers cross-complained for, I guess we call those bus fees and reimbursement of the settlement, of course. And then Textron cross-complained for bad faith. So it got pretty complicated. And the dispute was over what coverage trigger would apply. In California, the coverage trigger is the continuous trigger. So in this case, Esther's had, I guess Textron had experts whom they probably had borrowed from Esther's, saying that she had been exposed as a young girl, a 9-year-old girl, when she did her mother's laundry in 1966 or 64, or something like that, 1964, I think. And you can see the policies covered 66 to 87. So Esther's wasn't diagnosed until 2010. So under the manifestation trigger, which is what was applied in Rhode Island, the claim would not have been covered. And the reason that the Rhode Island law was important was that back in the 80s, Textron had filed a kind of a mass action against, what have I got here, 49 carriers, including Travelers, regarding claims in 19 states under 258 policies to try to get a ruling that Rhode Island law would apply. I think Textron was based in Rhode Island at the time. So both sides filed summary judgment motions. Textron's summary judgment motion was denied. You can see a reference to Civil Code 1646 that the terms of a contract must be interpreted by the law and usage of the place of performance, namely California. Textron's MSJ was denied. Travelers' summary judgment motion basically argued it's Rhode Island law that applies, and Textron is collaterally and judicially stopped from arguing to apply California law because they went to court, after all, to get a ruling, which they got, that Rhode Island law applied and the manifestation trigger would be applicable. So the trial court denied Textron's summary judgment motion, but then there was a PALMA order. It's a kind of an inside baseball appellate issue, but basically the PALMA order is what a court of appeal does to telegraph to the trial court that we're going to reverse you. So we're going to give you one last chance to straighten your act up, or you're going to get reversed. And so naturally, when that PALMA order came out, it went back down to the trial court. The trial court granted the summary judgment motion. They heard what the Court of Appeal had told them. And then when Textron appealed that ruling, the Court of Appeal reversed. And that's why I say with apologies, right? So and there's actually a footnote in the case, a fairly long footnote saying, yeah, well, we didn't actually see everything in that posture that we ultimately did see when the case was appealed. And we're sorry to the judge. They named him by name, Beckloff, in the Superior Court here in LA. So the case really is a choice of law case. And its choice of law, of course, is very complicated. And you can see the details there on the slide. And basically what it boiled down to was an issue of identifying the actual issue that was adjudicated. So the legal issue has to be identical, even if the current case involves other facts or legal theories. And they found that the Rhode Island case had not really considered the choice of law applicable to this particular personal injury claim. And it hadn't really considered the interest of California in having its own law applied. So it's a very complicated case, and and it's only an insurance case because it involves insurance. It'll probably get cited for the most part for choice of law issues. Now, Lewis versus Liberty Mutual is also a choice of law case, but it involves a claim against a manufacturer that was insured in Australia. I think the parent of the manufacturer, ETS, I can't recall, was an Australian company. And the policy that they had designated Australian courts and law. It was a choice of law policy. And so this case actually was an 11580 case. So that means that the manufacturer filed for bankruptcy during the pendency of the action. And so the claimants, who were a family of a young girl who was very severely burned when this fire pit exploded. You see that she got a $45 million judgment in Sonoma County Superior Court. So obviously the damages were serious. And then they proceeded against the insurance company under Insurance Code 11580. And the problem was that the date of the incident was in a policy period subsequent to one that would have covered her claims, but the policy that incepted as of, I guess, May 1st of 2014 reduced the limits and excluded coverage for a product without a flame arrestor, which is what this fire pit had, no flame arrestor. So the carrier moved to dismiss. This is a federal case now. So the carrier moved to dismiss based on forum nonconvenience, and the motion was granted on the principle that an 11580 plaintiff stands in the shoes of the insured and has no greater rights against the limitations of the policy than, or defenses the carrier could have raised, than the insured would have. And that's what happened. So the plaintiff, we can go to the next slide, please, Steve. The plaintiff in this case argued that to apply forum nonconvenience and apply the choice of law provision would be a violation of public policy, and she would have been deprived of her day in court. So the court looked at the Ninth Circuit looked at 11580 and 678.1. 11580, I think we're all pretty familiar with. 678.1, I did not know about before reading this case. It says that the insurer has got to give the insured at least 60 days notice of material policy changes, or the original policy would remain effective for 60 days thereafter. The plaintiff argued that the manufacturer had only received a 72-hour notice before the policy lapsed, and so her position was that the incident, which occurred in June of 2014, should have been covered under the terms of the prior policy, and that was the argument that she was going to make wherever the case was heard. But the court didn't find that either one of them evidenced a strong public policy that would preclude enforcement of the forum selection clause. And they also decided that our friends in Australia run a legal system that would not deny the plaintiff her day in court, even if there are some laws that would be less favorable to her. And then they went to, of course, the interests of the forum state in adjudicating the insurance for its citizens, which includes the manufacturer's parent. And they, as I say, the Ninth Circuit affirmed the trial court's ruling granting the forum nonconvenience clause based on the choice of law provision. All right, Steve, back to you.
Okay, one more third-party case. This one has to do with the scope of coverage for malicious prosecution under personal and advertising injury that you find in most commercial general liability policies. The situation here was that the insured KLA had been sued on something called a Walker Process claim. Walker Process is the name of a US Supreme Court case which found that you can state an antitrust cause of action for using a fraudulently procured patent in an attempt to monopolize the market. KLA had been embroiled in years of litigation with a competitor. There were patent invalidation claims, patent infringement claims, product disparagement claims. By the way, I looked up what these competitors manufactured, and the answer was they were manufacturing products in the active dopant metrology market. And I Googled that, and I still have a hard time understanding exactly what that means, but I think it has something to do with semiconductors. Anyway.
No wonder the patent was fraudulently procured. The patent office probably didn't even understand the industry.
So in connection with, the ultimate Walker process claim, KLA turned it over to its CGL carrier and sought a defense under the personal injury coverage, specifically arguing that a Walker process claim is a species of malicious prosecution. The trial court granted summary judgment for Travelers, which was affirmed by the Court of Appeal. KLA argued that the term malicious prosecution was ambiguous because it had previously been construed to cover abuse of process claims, and that the insured would reasonably expect it to encompass claims before the Patent and Trademark Office. However, the Court of Appeal found that a Walker process claim does not necessarily involve legal proceedings, because proceedings before the Patent and Trademark Office are non-judicial in nature and therefore did not fit within the reasonable expectation of the insured as to what would be covered under a malicious prosecution claim. The mere fact that there had been this background of prior litigation did not convert the Walker process claim into a malicious prosecution claim. So that is it for third-party claims. I'm now going to jump into some insurer versus insurer cases. As I mentioned at the top, the big California Supreme Court case in the area of insurance this year was Montrose Chemical versus Superior Court, actually known as Montrose 3, because there have been two prior published decisions arising out of this dispute, which, as we'll see, has been winding up and down the court system since 1995 or before. That's because there was a lot at issue and a lot of insurance policies at issue and a lot of layers of insurance policies.
It's Stringfellow, right? Is the location?
No, it's not. I thought so too. It's not Stringfellow. It's a different environmental cleanup. I think, but Stringfellow also resulted, I think, in one or more California Supreme Court cases in this area. Montrose manufactured DDT at a Torrance facility. So the facility was in, the cleanup is in that area. And it was that was from 1947 to 1982. It had purchased primary and excess general liability policies for a long, portion of that time, 61 to 85. And years later, was sued by the government to clean up the site, and ultimately entered into a consent decree for which it has so far expended $100 million trying to clean up the site and counting. So the coverage issue in this particular case has to do with the different layers. This bottom layer in my chart here is P for primary policies, and then above it, it had at least 2 layers of excess policies. Now, to understand why this problem rises, you sort of have to understand a couple of the prior holdings in Montrose and other related cases. The first holding is that when you have a continuous or progressive loss like this over many, many years, the Montrose 1 case, California Supreme Court held in 1995, that all policies on the risk are potentially implicated for that kind of continuous loss. That's called a continuous injury trigger. So all these primary policies down here at the bottom were potentially at risk. The second concept is that the insurer on the risk, when the loss first manifests itself, is on the hook for the entirety of the ensuing damage. So the loss is not just limited to the loss that occurred during that particular policy year. That's called the all sums rule. And then the third concept is in 2012, the California Supreme Court said that an insured may seek indemnity from all of the policies that were on the risk. So that's called all sums with stacking indemnity principle. So the insured can seek coverage from all of these primary insurance policies, which in effect create one giant mega policy. But the question that we came to in Montrose 3 was, does Montrose have to exhaust all of the underlying policies spread over the years before accessing a higher level, second level excess policy? Or in order to access this policy that has the question mark above it, is it only necessary to exhaust the two policies immediately below it? And the answer was, as it turns out, the answer is that they do not need to exhaust both the primary and the first level excess. It's sufficient only to exhaust the immediate policies below the policy in question. So in analyzing, trying to figure out the answer to this question, the California Supreme Court looked at the language of the excess policies, which all provided that the insured must exhaust the limits of underlying insurance in the same policy period before coverage is triggered, but they also contain other insurance clauses which require more broadly exhaustion of any other underlying insurance. And so Montrose, the policyholder, was proposing vertical exhaustion. We don't have to exhaust everything that's below us, whereas the insurers were proposing or arguing for horizontal exhaustion. The facts of the case were that all of the primary policies in this particular case had been already horizontally exhausted. So the question as to what had to be horizontally exhausted really was just relating to the first level excess policies. So the trial court granted summary adjudication to the insurers, saying that horizontal exhaustion should apply, and there was Court of Appeal case law to that effect at the time. The Court of Appeal then affirmed that decision, but the Supreme Court reversed, finding that vertical exhaustion is appropriate. So the holding was the insured has access to any excess policy once it has exhausted other directly underlying policies with lower attachment points. But it added, an insurer called upon to indemnify the insured's loss may seek reimbursement from other insurers that issued policies covering relevant policy periods. So in other words, the carrier that gets tagged in the first vertical exhaustion is free to sue the other carriers for contribution and argue amongst themselves as to what the proper allocation should be, but the policyholder doesn't have to litigate those issues. The court found that while the insurer's interpretation of those clauses was not unreasonable, they could also be read to refer only to directly underlying insurance in the same policy period. The other thing is that other insurance clauses have generally been used to allocate concurrent policies, not successive policies. And also the court found convincing that the excess policies explicitly stated their attachment point by referencing specific dollar amounts of underlying insurance. So since there was a potential ambiguity, the objectively reasonable expectations of the insured controlled, and the court ruled in favor of the policyholder, and noted that horizontal exhaustion would create as many layers of additional litigation as there are layers of policies. And certainly the Montrose case itself would tend to support that conclusion. Now, the court did not decide whether it was necessary to exhaust, going back here, to exhaust all of the primary policies before accessing the first excess level. It was only talking about second level excess policies. But interestingly, within a month or two of the decision in Montrose, the Court of Appeal, I forget which division, came down with the Santa Fe Braun case, which answered that question that had not been resolved by Montrose 3. That is, where you have not fully exhausted the primary levels, can you go after an excess policy that exists above one of the primary policies? So this was, again, a continuous trigger type of situation where Santa Fe Braun was sued for asbestos-related bodily injury spread over multiple years. And Braun sought a declaration that its excess insurers were obligated to defend and indemnify. The trial court ruled that horizontal exhaustion was required unless there was something in the excess policy that expressly provided for vertical exhaustion. And again, there was Court of Appeal case law to that effect at the time. But on appeal, citing Montrose 3, the Court of Appeal found that the other insurance clauses were the same as in Montrose 3 and that the same analysis applied. And so the court ruled the same way. The insurers argued that, yeah, but Montrose 3 involved excess policies, whereas the exhaustion of excess policies, whereas this case involves the exhaustion of primary policies, and primary and excess policies are different. There's a different risk analysis, premiums are calculated differently and so forth. But the court said, well, no, the language of the clauses is the same, and so we're going to interpret them in the same way. And in the process, the court rejected these prior two cases that I've been mentioning that did find that horizontal exhaustion of primary policies is required. So obviously disagreed with them. The parties, the losing side, the insurance company, did petition the Supreme Court for review of the case, and the Supreme Court denied review. So presumably, I think that Santa Fe Braun has changed the law in this area. Let's see here. I've got one more insurer versus insurer, and then I want to make sure we get to bad faith cases. So this one was an excess carrier that was called upon to pay a settlement and wanted to second guess the earlier decisions of the primary carrier to pay an underlying different settlement, saying that it was not covered. And that it therefore improperly eroded the policy limits, so the excess carrier shouldn't have to pay. And the situation was the policyholder was Northrop Grumman, and it had 3 levels of employee benefit plan fiduciary liability insurance, as you see: National Union, Continental, and then Axis. National Union contributed to a settlement with the Department of Labor relating to pension plan violations, which exhausted its policy. Continental, the second layer or the first layer excess, then contributed to a different settlement, also relating to employee benefit plans. And that settlement exhausted its policy and implicated the Access policy. So although Axis paid the remainder of the settlement, it sued Northrop for declaratory relief, saying that the first settlement paid by National Union was not for a covered loss. The district court ruled in favor of National Union, but it seems to be a pattern today. The Ninth Circuit, the Court of Appeals, reversed and ruled in favor of the policyholder, noting that there was no precedent for a concept of improper erosion within the Ninth Circuit. And this is governed by federal law, by the way, because it relates to ERISA plans. But although it did also cite to some California law. And so absent some kind of specific language preserving a right to complain about what the primary policy did, the excess carrier cannot second guess what the primary carrier did in order to try and get out of paying. And so, Mike, I'll turn this next one over to you. Oops, you're on mute.
Thanks, Steve. We'll blow through Truck Insurance Exchange versus AMCO. You can see the site and you can see the slides that I prepared. It is something that you will see periodically in battles about additional insured status. The confusion of liability, in this case, one of the landlord's set summary judgment motion in the underlying case had been denied, and the tenant's MSJ was granted, and so the tenant's insurer argued, well, we're not liable, and the court has ruled on that, confusing liability with additional insured status, which is really very broad arising out of standard. So we can move into the bad faith territory now, I think.
Okay, let me just say just a couple words about these other two cases involving equitable subrogation, which is kind of an arcane area. But I think that there's this Pulte Home case, and then the following case called Carter, which also involved Pulte Home, is an important lesson for lawyers about how pigs get fat and hogs get slaughtered. What happened was in the Pulte Home case, Pulte Home, a general contractor, its carrier, sought reimbursement of defense costs from subcontractors and agreed that it was proper to allocate amongst the different subcontractors. Whereas in the Carter case, the same general contractor, different carrier, argued that that the subcontractors should pay 100% of the defense costs and that they were jointly and severally liable. Ultimately, the Court of Appeal in the first case found that, yes, the insurance company could make a partial allocation argument against the subcontractors on equitable subrogation. But in the Carter case, because the insurance company had argued that recovery was an all or nothing proposition, and that was not a proper legal argument, it was stuck with that argument and couldn't get a reversal to go back and allocate. So that's all I'll say about those cases. We can move on to bad faith.
That's a policyholder lawyer's analysis of the outcomes. Who would ever call insurance companies pigs or hogs? I don't know. All right. So all of these bad faith cases that I am talking about involve the application of the genuine dispute doctrine. And this Long Beach case, or Kookman, is interesting because it's a case where there was damage to this apartment building, and the argument was there had been a ruptured water main, but the issue was whether the ruptured water main had caused the damage or whether there was ongoing land settlement, soil movement, earth movement that was not covered under the policy. So when the claim was first made, the insurance company and its coverage counsel identified both possibilities. The theory that you apply when you have more than one cause is this theory of efficient proximate cause. Efficient proximate causation was not actually analyzed in the case itself, but it's in the next slide. It's 530 of the insurance code, and there's a case, very old case, as old as I am, Sabella versus Whistler, that describes how efficient proximate causation works, although it's still not crystal clear. And the bottom line was that the insurance company ultimately decided that the efficient proximate cause was earth movement and not the pipe rupture, and so they denied coverage, and the insured sued, lost at the trial court, and the Court of Appeal affirmed on the basis of the genuine dispute doctrine. Which is interesting because they looked at different things, different facts that had been brought up. The fact that the coverage counsel at first had said there clearly is damage due to the water main rupture, but there's also the issue of earth movement. And let's look at their utility bills to see whether there is signs of water, excess water usage, meaning there are leaks there. Derek Chaikin appears to know a little bit more about the case than he lets on. Anyway, ultimately, the decision was that there hadn't been excess water usage. There wasn't any indication of water causing damage before that, and so the Court of Appeal decided no, there's a genuine dispute there. The next case, Fadif, is the exact opposite in terms of outcome. The Fadifs owned a home that was damaged in the Lake County fires in 2015. And fortunately, it looks like the house didn't actually burn. The claim was for smoke damage. State Farm accepted the claim, paid for mitigation and cleaning, including power washing of the interior. And its inspection report at that time said that the house was well maintained with no apparent deferred maintenance, and all damages related to smoke and soot. And that was important because FDIF then submitted a second claim, a supplemental claim through a public adjuster. That time, the adjuster for State Farm was a different adjuster, not licensed in California or in any building trade. And this inspector said there's no smoke damage, didn't look behind light switches, for example, inside walls, that sort of thing. And State Farm had also hired inspectors for the HVAC and the home itself. Didn't follow operations guidelines, like I say, only took surface samples, denied the supplemental claim, and FDIF sued for bad faith and lost. And State Farm, of course, argued genuine dispute. Look, we relied on the experts. And the trial court ruled for State Farm on its summary judgment motion. And then the Court of Appeal reversed, finding that the genuine dispute doctrine wasn't applicable because State Farm had not proved that its reliance was reasonable. So the insurer can only claim a genuine dispute based on a full, fair, and thorough investigation. The exterior paint, the insured argued, was due to the power wash itself, and the Court of Appeal looked at these different things: unlicensed inspector, the initial inspector report that said well maintained. We can go to the next slide. Failure to use the operational guidelines. So it shows you that these genuine dispute cases really are very fact intensive. And on both sides, you need to be able to use the facts either to demonstrate that there's something rotten in Denmark if you're the policyholder's lawyer, or everything's on the up and up if you represent the insurer. There are a couple of quirky things in the case that I spotted. One of them is the Court of Appeal can decline to consider arguments raised only in a footnote. The court actually said that in this FDIF case, and they cited to this Sabi case. I wasn't aware of that, and if you're writing an appellate brief, be careful about that. I have the feeling that's something that a Court of Appeal would only cite if they're going to rule against you anyway, but it's kind of, put a pit in my stomach. The other thing is, when the FDIFs were deposed, State Farm's lawyers asked questions like, did you ever feel that folks at State Farm wanted to hurt you? Were they mean to you? Did they have those sorts of questions? Did you ever feel that they were trying to harm you? And they used their deposition responses in support of summary judgment against punitive damages, which the Court of Appeal also ended up reversing. But again, both sides recognize that those kinds of questions can be asked. I guess it's more of a policyholder warning than an insurance lawyer's warning. You have to be careful about those kinds of questions, even though the Court of Appeal said, look, those kinds of questions don't show the absence of malice, oppression, or fraud. And the whole case is based on fraud, after all. If you can prove it, you'll get punies. But I thought it was interesting from a litigator standpoint. Oh, okay, now this is Gazarian. Gazarian is another bad faith case, and again, a genuine dispute case, but the Court of Appeal ruled against the insurance company on this one. So basically what we have is 2-1 in these genuine dispute cases last year. This is a health insurance case involving an autistic child who was getting ABA therapy, very intensive therapy, for hours each week. And he was getting 157 hours per month. And then when he turned 7, the carrier, which was Blue Shield, denied the claim and only approved 81 hours as medically necessary. The Department of Managed Healthcare has a review process, and they have 3 independent physicians. And the review board reversed the decision and said that the patient should get the 157 hours per month by a vote of 2-1. When Gazarian sued for bad faith, Blue Shield said, well, look, we got one doctor who agreed with us. Obviously, there's a genuine dispute. We can go to the next. And the trial court agreed with them, granted summary judgment, and then the appellate court reversed. and they said the trial court had erred by failing to look past arguably reasonable denial, right? I mean, hey, we got a doctor to review with us to determine whether the insurer had fairly evaluated the insured's claim. And the issue was medical necessity. Is a blanket rule, which was what Gazarian argued, that says that at the age of 7, the patient will get less ABA therapy medically necessary. And there were arguments. Actually, there were arguments only on the side of Gazarian because Blue Shield had stopped at their argument at simply saying, well, we got a doctor to agree with us, and they didn't argue medical necessity. And having not shown that medical necessity guidelines were consistent with community medical standards, they were unable really to show that they had reasonably relied on this policy, which of course predated what the doctor had ruled. There's a little bit of treatment of bad faith, of unfair competition there. What's interesting about that is, a few years ago, they added to the unfair competition law provision for standing where you had to have actual damage. And the court in Gazarian noted that if you have to pay a lawyer to get your benefits, that's actual damage that will confer standing for under the UCL. All right. The next one is yours, Steve?
Yes. Yeah. Okay, and we're doing good here. We should finish just right about on time, get through everything. So Trilogy Plumbing, not technically a bad faith case, but it arises from a bad faith case, and I think is of interest to practitioners in the area of insurance coverage cases and bad faith cases. It's at least the second anti-SLAPP case that's come down recently against insurance companies trying to use the anti-SLAPP statute. So Trilogy Plumbing had been sued in multiple construction defect cases, and its insurance company, Navigators, according to Trilogy, was trying to save money by instructing the defense attorneys not to vigorously defend the case. Trilogy filed a complaint for bad faith, alleging that the insured had given improper instructions to panel counsel and negotiated settlements without Trilogy's consent. And so in response, Navigators filed an anti-SLAPP motion on the theory that, well, these are communications with lawyers or about lawyers, about legal proceedings, so they should fall within the scope of the anti-SLAPP statute. The trial court denied the anti-SLAPP motion, and the Court of Appeal affirmed the denial. The anti-SLAPP motion had targeted allegations specifically about settlement negotiations or communications regarding the control of Trilogy's defense, such as conflict issues that were allegedly arising between panel counsel and its two clients, the insurance company and the insured. But the Court of Appeal found that the allegations were not based on a written or oral statement or writing made in connection with an issue under consideration by a judicial body. Rather, the things that were being complained about by the policyholder in its lawsuit were merely incidental or collateral to judicial proceedings, and so they were not subject to the anti-SLAPP statute. Another way of looking at it is the challenged allegations pertain to Navigators' conduct in mishandling the claim process, not really a speech issue. And also that the plaintiff was not suing the lawyers that had been hired by the insurance company. It was only suing the insurance company itself. So the relief it was seeking, related to the insurance company's conduct, not to lawyer conduct. And you just have these, the references to what was going on in the underlying litigation were for context, but the case was really about Navigators failing to perform under the terms of its policy. And as I mentioned, this is the second Court of Appeal decision to find this way. Another one a couple years ago now, Miller versus Zurich American Insurance Company, reached the same result. So that's good news for policyholder lawyers. I would imagine that for policyholder lawyers filing bad faith claims that may still be met with an anti-SLAPP statute, given these two cases, the policyholder's lawyer could probably argue for sanctions under 128.5, as is permitted by the anti-SLAPP statute when you oppose an anti-SLAPP motion that you can show was brought in bad faith. There's really not much of a basis for them now. Okay.
Yeah, I think the key issue in all these cases is that it's the carrier that is the defendant, not the lawyers themselves, right?
Yeah, I think that's right. So one case that's worth spending a couple minutes on relating to broker negligence, because after many years of broker negligence claims contracting in the state of California, I think it's fair to say that there's been a couple cracks in the armor in the last couple of years, essentially holding that, well, yeah, brokers generally aren't really liable for much, insurance brokers, unless they hold themselves out to be specialists. And if they do, then they can be potentially tagged for negligence. So in this case, the plaintiff was shipping $40,000 in used computer equipment via UPS. UPS directed him, he asked about insurance, and UPS directed him to one of its subsidiaries, UPS Capital, to purchase insurance coverage, and UPS sold him a marine certificate of insurance, this very obscure area of insurance law. The equipment was damaged in transit, and so Murray filed a claim, but the claim was denied because it turned out that this specialized type of insurance that was sold by UPS only applied if the entire truck that the computer equipment was in had been destroyed, and that wasn't the case. And so Murray said, well, I didn't understand that. Nobody told that to me. The carrier cited this free from particular average provision, which I'm not going to read the whole thing, but if you read it to yourself, I challenge anyone on this call to explain to me what it means. Warranted free from particular average unless the vessel or craft be stranded, but notwithstanding this warranty, blah, 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 blah. I mean, I'm do insurance coverage for a living, and I find this clause to be incomprehensible, and so did the court. And so Murray sued UPS and said, hey, you owed me a special duty. The trial court granted summary judgment for the broker, but because it found that there was insufficient evidence that UPS Capital was holding itself out as an expert, the Court of Appeal reversed, saying that public policy supports the creation of a reasonable inference of expertise when there is evidence the agent specializes in a particular field of insurance. And in this case, UPS, UPS Capital literally was a subsidiary of UPS. And on top of that, and it only sold this one policy, by the way, it didn't, sell policies for other carriers, didn't sell other policies for this carrier. This is all it did. And, on top of that, the policy was quote unquote impossible to decipher. So the court reversed summary judgment and found that there was a triable issue of fact as to whether UPS had assumed a special duty. So we're at 129. The last thing that I'll do is look ahead to this year. What's on the California Supreme Court's docket in terms of insurance? This year, I think we can expect a decision in this case that came from the Ninth Circuit, Yahoo versus National Union, which has to do with whether Telephone Consumer Protection Act cases relating to unsolicited text message advertisements are those potentially covered under the right of privacy coverage that comes under personal and advertising injury. So stay tuned. That'll be hopefully or probably part of next year's presentation. And so with that, I think we have finished.
Well done, Steve. Thanks, everybody, for joining us. We hope that you found this entertaining and educational, and I guess we'll see you next year.
Bye, everybody.